You're not controlling this courtroom, sir. That's not how this works.
I'm speaking about what I have a right to do. I have a right to respond back. So
you're going to get 5 minutes and I'm going to be done. So that is your opportunity. And after that, I'm going to make my rulings. You got 5 minutes. I'm actually setting a timer.
He tries to take control of the courtroom, but it backfires instantly. The judge steps in and out everything, shifts in seconds. What follows only escalates the tension even more.
S00425.
Rachel McDuffie for the people.
And standby counsel, Assistant Public Defender Jay Bellinger from Mr. Eric Martin, who appears via Zoom. Mr. Martin, can you please unmute and state your name for the record?
I'm a living man, capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N family. One of the people, sovereign, not a legal fiction corporate entity defendant with a name similar to mine. I'm here by special appearance to threaten duress, not willingly. Now, again, I object again to any attorney being appointed to me, representing me. But that's something I want to ask you, Washington. Now, you said you're appointing this public defender. Are you appointing it for me or are you appointing it for you? Or is it just standby?
I made my decision on that. It's standby counsel. If you have motions to make, you need to make those at this time.
Yeah, that's how I need. I'm seeking clarification. Are you appointing him against my will to have an attorney appointed for me?
Yes, it's not representing you. He's standby counsel. Please make your motions.
Yeah, that's it. Well, that's I was going to make the motion to dismiss him if you're trying to appoint him for me, which, as I already said before, I will not be taking no attorneys. I'm one of the people. I'm not a defendant who's, yeah. So as I said before, so I'm not going to be accepting any attorneys who's going to fraudulently assume I'm a defendant, and which would then fraudulently give the presumption I'm under the jurisdiction of the court, which I'm not. As I said before,
you got 5 minutes to make your arguments.
At this early stage, the direction of the hearing is already becoming clear. He is focused on challenging the authority of the process itself rather than addressing the situation directly, while the court allows him time to speak. There is a growing sense that both sides are operating from completely different perspectives, which starts to shape how the rest of the exchange unfolds.
You can spend them however you want to.
All right, yeah. Like I said before, I'm a living man. So as the U.S. Supreme Court said in the cases I cited to you before, there's no jurisdiction over a living man. Corporations don't have jurisdiction over a living man without our consent. I don't consent. And it's also under, there's no consent under the Declaration of Independence of 1776. There's no jurisdiction over a human without their consent. So I never consented to jurisdiction, and I don't now, and I never will. Now I have some questions though for the prosecutor. That's
Sir, you don't get to ask questions. If you want to have a motion, you can make those.
Well, I object to that. That violates my right to a due process. It's relevant to a standing argument as to the prosecutor, whether they have standing or not. I think that's relevant to move forward or not, you know. There's no standing, shouldn't move forward, but so what's your ruling on that?
Your motion is denied as to jurisdiction and standing. Now, do you have any additional motions?
I object to that because you didn't allow me to answer the questions to see whether whether you had a legit basis to make that ruling.
Your objection is noted. Next.
Okay, let's see here. You say you're going to be questioning me about the some demands that made to dismiss the case anyway, right?
I'm sorry, what?
You said you're going to be addressing some demands for dismissal I made or sent to you already,
So
you're gonna
first of
be,
all, a demand is not a proper format before a court and could be dismissed outright. However, I'm going to allow you to make your motions here. If you want to make an argument, you can do that, sir.
I object to that. That's not true. As I mentioned before, demands, when someone has the right to something, that's what the terminology, demand is made. And that's the only reason why I make it. Motions, even though I know that's all you see in the court rules or whatever, traditional. But that's for a request, and persons are not, or humans are not supposed to be requesting constitutional rights. You know, me exercising my unalienable right, human rights and constitutional rights, I'm supposed to be making demands. That's how I've been, and that's backed up by law. And that's how I've been taught. And so that's what, so it's all right and proper. Motions are requests, you know. And the defendant makes motions also, since I'm
So you're
disputing.
about to end of your 5 minutes.
Well, I objected 5 minutes being any time limit also. That violates.
I don't care about what you're objecting to. You can make it on the record. It is noted. Now, if you have something that you want me to address, you should do that before your time is up.
Putting a limit on my First Amendment right, that's unconstitutional. So I
Sir,
object to
this is, sir, please, if you want to have something to say, other than the circular talk that you're doing, you should probably do that at this time.
that. I didn't finish. That's why I didn't mean to, none circular. I didn't finish the first time. All right, well, that's it. As to that,
Is the court ready for the people's response run?
I don't know if he's done with his motion.
Oh, I'm sorry.
I'm trying to make,
um, well, the police, I want to question the police officer who wrote the ticket. I have a relevant question to him as to self-incrimination, move to dismiss the case based on that, because he made me give, my ID. But my memory was it's a little, I don't really remember exactly what was said. That's why I kind of need to question him to refresh the memory. But I do remember in general, though, he kind of, I'm required to give my ID if I remember right, and I might have been arrested if I didn't give my ID, which is under threat and duress. And even if he didn't say that, which I don't remember, which, like I said, I need to have his body cam and all that. I want that. I want to be able to review that now, and also for the trial, if this goes to trial, I want the video present as part of my due process right for the evidence, which is my due process right, like I'm saying. And because, like I said, it violates my self-incrimination right, that I'm being made to give my supposed name, government name, anyways. It ain't really my name, but a government name has been given. Violates self-incrimination. And then it's used against me to prosecute. So it violates self-incrimination. Yeah. Move to dismiss based on that too. And like I said, if you need more evidence as to, like I said, his questions, then he needs to answer my question. I was about to send out interrogatories to him. I'm about to do it here soon. If you find that's necessary, unless you find it ain't necessary, I'm gonna send it out soon. So. Oh, another thing. Now, Mrs. Washington, I just filed a federal civil lawsuit on you, for violating my constitutional rights during this case. So you may want to consider recusing yourself. I know you probably didn't get a receipt yet because I just sent it out like 2 days ago. So the court will be getting it, if they didn't get it already, be getting it this week. And yeah, so I want that out.
as to your motion to recuse, that is denied.
Based on what reasons? conflict of interest is my reason. That's why I didn't mention that, but I thought you might kind of already figure that. But conflict of interest due to the lawsuit being filed, that's the grounds of my demand for dismissal.
Okay.
And I would like to, Ms. Duffy, as the prosecutor, I'd like to notify you, of the crimes being committed against me by the police officer by, in this case, writing the tickets, and I request you prosecute them for this because I'm the crime victim here in reality. Because I was traveling by right, which the U.S. Supreme Court said we have, as long as you're not carrying passengers property for profit, you're not technically driving a motor vehicle. Therefore, all these charges are baseless. There's no case here. So in reality, I was harassed, retaliated against for exercising my right to travel on my motorcycle, and then with these charges.
Here, the approach becomes more structured as he expands on his position. He shifts into explaining his reasoning in detail, but the gap between what he is presenting and what the court is expecting becomes more noticeable. Moments like this often determine how the remainder of the hearing will progress.
Okay, so because they had no evidence that I was carrying passenger property for profit, which is what's required. That's the definition of a motor vehicle under 18 USC section 31 subsection 6 and 10. That's when a motor vehicle is a motor vehicle. In contrast to the state law, I know what the state law says. The state law just says, oh, if something's mechanically drawn, it's a motor vehicle. Well, the state statute is in violation of this federal statute. Therefore, it's unconstitutional. Okay, and therefore, the federal statute definition of motor vehicle applies here. It overrides the state statute under Article 6 of the U.S. Constitution. Laws of the United States is supreme over state law. So therefore, I wasn't doing anything wrong. I was traveling by right on my motorcycle, as I have a right to do, without a license, without registration, without insurance. So I was all within my right under that federal statute and the U.S. Supreme Court case law that I cited already in the court that they sent back. But one of the main cases here is Packard versus Banton, U.S. Supreme Court case law. Okay, this is a little more specific than just saying people have a right to travel. It mentions here specifically, and I'm gonna mention right here, Volume 44, Supreme Court Reporter, page 259. The streets belong to the public and are primarily for the use of the public in the ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislator deems proper. So as they're saying right there, so we do not need a license if we're not using the streets for profit, for gain. I wasn't doing that. The police don't have no evidence of that. So he shouldn't even pull me over, stop and wrote a ticket, none of that. So I'm the crime victim. I request you prosecute him for that. And it's also a federal crime, which I'm gonna be contacting the FBI about. I already tried once. I gotta call him back. So yes.
Anything else, Mr. Martin?
Well, I'm gonna see if you got my if you're gonna I would like to just reiterate my the demands for dismissal already made, or if you want to call them motions, but like I said, I like using the word demand because I don't agree to no unlawful presumptions that because I understand the legalese a little bit where you say one word and it means something else and it's presumed, and that's why I demand also that there be no legalese used in no stages of this case, because that's one of the fraudulent things going on in the court system. I'm gonna be filing a class action to stop this on a grand scale, but I know it's happening. That's why, like, for example, I use the word demand to use the word motion, and it can be presumed you're a defendant. Because defendants make motions, see? So that's why there should be no legalese used here. It's fraudulent, it's wrong, it's immoral, it's pathetic. Whoever made this stuff, because it's putting it's a blanket on a lot of people that don't know no better in the system. Something else. Now, when this proceedings started, I noticed on the screen, it said no recordings are allowed. Okay, now I object to that, in that violates my due process right to preserve evidence, me or anyone else, and I'm not just speaking for me, I speak for everyone else. All the people have a right to record in any public court. This is all public. U.S. Supreme Court already said this. People have the First Amendment right to record in public anywhere. And it's also a due process right to preserve evidence. Because if my rights are violated during these proceedings or any other, along with anyone else's, we have the right to record that and have that evidence to bring criminal or civil charges. So that's why that's not supposed to be popping up on the screen that video, audio recordings ain't allowed.
Right, thank you, sir. Ms. McDuffie.
Thank you, Your Honor. So I am aware of 5 items that have been filed by Mr. Martin, I think after this case began to be pending in this court. And I'll just briefly address the as to the formatting of those. I did notice all of them are handwritten. He does write a date on the top of each document, but then he usually signs off with a different date on the bottom of the document. So if it ever comes into play that there's an issue with the timing with respect to deadlines or anything like that, for my purposes, I'm just going by the date that it was received by the court, which is usually a third date that is different from the other 2. So the first document I'm aware of is titled Demand for the Return of My Motorcycle. That one was received by the court July 27th, or yes, I believe somewhere around there. I'm sorry, I'm not going to the dates aren't really important, so I'm not going to dwell on those. I'm just addressing these versus actually, I think, responding to them in detail. Defendants specifically ordered and demanded that the troopers from Michigan State Police return his motorcycle in this case. That is a request to police that was filed with the court. No response appears to be required or called for from the people, so I don't have anything to say about that. Next is the motion that was filed for the disqualification of the judge in this case. And I just wanted to point out a couple of things. First and foremost, as Mr. Martin pointed out, the court rule that relates to disqualification of judges, MCR 2.003, speaks to the exact procedure for that. In a single judge court, and actually the challenge judge here is the chief judge, the challenge judge is the person who decides this motion. So I don't have any argument to make as far as that, but I would point out there is a quote included in that particular motion that challenges this court's jurisdiction. And it cites a case from, what's that? Oh, yes, Penhallow versus Jones Administrators. That's a case from 1795. And the specific quote that was cited in that case to challenge this court's jurisdiction, it's a paragraph or so. It begins with something about, heavens, let me see. I want to make sure I have it correctly. I don't want to, it's not really important. In as much as every government is an artificial person, a creature of the mind only, all that stuff about artificial persons. I think Mr. Martin already made some references to that. I just want to make sure that Mr. Martin is aware that specific quote does not exist in that case whatsoever. That quote that he used to challenge this court's jurisdiction doesn't exist anywhere at all, except for other cases where sovereign citizens have copied and pasted that non-existent case law, and they've been told the same by other courts. So apparently there's like a bank of things to be shared amongst people making this argument, just so he knows and everybody else out there knows that does not exist. It's not a thing. It's nowhere in that case. That full text of that case can be Googled for free. You will not find that quote. The same is true of another case he cited, Keller versus Potomac Electric Power. That's from 1923. That case also does not include that quote, those words, or anything even slightly resembling that argument regarding the power he believes is lacking here due to municipal court status. But FYI, the Michigan District Court Act of 1968 did abolish most of the municipal courts. 4 of them are left that they did allow to remain: Grosse Pointe Farms, Grosse Pointe Park, and Grosse Pointe Woods. All of those are in Wayne County. We're in Washtenaw. So just so that Mr. Martin is aware, this is not a municipal court. It's a district court. Finally, as to the motion to disqualify, as I mentioned, that is for the judge to decide. But I might want to point out the manner in which he chooses to pursue that disqualification, including any comments or insults. For example, on page 9 of his motion, when he says that also, Washington is not a real judge, but a clerk masquerading as a judge. Pursuing disqualification or recusal or even a federal lawsuit does not insulate you from the contempt powers of that very same court should you choose to continue escalating that type of behavior. That's just the more you know from me. Third, next document that was filed from this court, it's titled Martin versus Mike. Plaintiff's response and response and objections to my return criminal complaint on Mike and the attached court letter that vaguely, unfairly stated filings does not comply with MCR 6.101 and 6.102. I didn't have a letter attached to that to refer to, but it looks like that is the court's rejection of an improper filing or format. I honestly have no idea who Mike is, but the people of the state of Michigan are not listed as a party in that filing, so I don't really have any response to that either. I can advise, though, that Mr. Martin mentioned earlier, and it's stated here, that the reference to this criminal complaint, because a defendant refers to himself as a plaintiff and title something as a criminal complaint, it doesn't make either of those things true. So I'll direct Mr. Martin to the same court rule he actually cited in that filing, which is MCR 6.101. The prosecutor's approval or posting of security. A complaint may not be filed without a prosecutor's written approval endorsed on the complaint or attached to it, or unless security for cost is filed with the court. I just wanted to disabuse him of that notion that because he creates a criminal case, I guess in his mind and on paper, it doesn't mean that that exists in reality. So nothing more from that. The court's rejection of an improper filing really isn't my business. So no response from opposing counsel would apply to that. The last two things that were filed before the court are two demands. The court has already mentioned demands. I'm so sorry. It's a lot of talking happening here. I gotta refresh. Two demands. One demand for default judgment and another demand for summary judgment. Both of these I would have the same reaction to. The demand for summary judgment, summary disposition concerns parties to a civil action, and defendant is referring to civil procedure, not criminal procedure. There is no summary anything of that notion in criminal matters. Now, he made some references to Article 3 of the US Constitution. That pertains to federal courts, appointment, tenure, Supreme Court justices, federal circuit and district judges. Those are Article 3 judges. Those are the ones nominated by the president, confirmed by the US Senate. So this court is not controlled by Article 3 of the US Constitution. But I think he knows that because he's citing Michigan court rules to sustain his argument for pretty much everything else. So that doesn't change here. Summary judgment is not a thing here. Default judgment. Now, that's not quite the way it works. I think he argued that because the prosecutor in court did not respond to the request to return his motorcycle for that first filing that I mentioned, that he should have a default judgment and he should automatically get what he's demanding because he didn't respond to it. Well, I'm responding right now, but that's not how it works either. Again, this is kind of a civil issue. There are cases where there are default judgments filed, but those are civil actions. We have traffic tickets that defendants fail to appear and get a default judgment. But if that were the case, I would have a default judgment of conviction for every criminal case where defendants fail to appear. People are on bench warrant status for 6 to 20 years at a time. I don't get automatic default convictions. So again, that's really not what's happening here. So those are the 5 things that I'm aware of. Now, finally, if it were true that, as Mr. Martin stated, that federal law trumps all state law, and that all state law and state courts are unconstitutional, the state court system would not exist, and the US Supreme Court would not hear cases resulting from the need to interpret state law. Mr. Martin has yet to hear, as all of us do, of state constitutions and the power of the state courts that come from those being abolished. So his reference was correct, that there are people in this system who don't know any better and don't know what they're doing. I don't think present company is excluded from that. So on that note, Mr. Martin, if you want to continue without an attorney, you can, but I wouldn't recommend it. That's all from the people.
It's a surprise you wouldn't recommend you're a prosecutor. But anyway, well, I think that she said so much. I took some notes, but I couldn't take notes on everything. Hard to follow along with everything else. I think it's best to, same with me too. I say one thing, allow her to respond back. She says one thing, then allow me to respond to one set of, you know what I mean? Like me saying a whole bunch, and then her saying a whole bunch, because it's hard to follow along for both of us, I think, harder. At least me, and for both, I think it's common sense, but All right, well, so I'm gonna respond now to things I could follow along with, and I took some notes. But I could, I'm gonna need her to say again what I missed, and then I can respond one by one. Okay,
That's not how this is gonna work, sir.
that's
I
not
think
how,
to understand here,
I have the right to that. What are you talking
you're
about?
not controlling this courtroom, sir. That's not how this works.
As I'm speaking about what I have a right to do, I have a right to respond back. So,
You're
all right,
gonna get 5 minutes and I'm gonna be done. So that is your opportunity. And after that, I'm gonna make my rulings. You got
So-
5 minutes. I'm actually setting a timer.
all right. Again, I object to that again as being violates my due process right to the First Amendment. It's not supposed to be regulated by a certain time limit. My First Amendment right to say what I got to say, based on an arbitrary, unfair time limit.
Sir, in a minute, you're pushing towards being in contempt of court. You got 5 minutes. You can make your objection, which you've done. You got 5 minutes. Now please move forward.
Criminal. Okay, I want to object to that too, though, about what you said about contempt of court. Exercising the First Amendment is not contempt of court. It's nowhere close to that.
There's no First Amendment right in this courtroom, so you're a defendant. You need to actually do what is requested of you, and I'm giving you an opportunity to make your argument.
As to the criminal complaints, in response to what you said about that MCR, the refusal to act on my criminal complaints that I filed because of MCR 6.101. And now, first of all, they violated my due process right, obviously, because they didn't mention a subdivision, a subsection of that rule. There's many subsections. Okay. So I'm still left in the dark on what specific subsection it is. And all those apply to specific fact situations. So that was the first due process violation right there, just mentioning that too vaguely general. Number two, but assuming it was based on not paying a fee or whatever, I think like she mentioned, or getting a prosecutor's approval. Okay, if it is for that reason, those reasons are unconstitutional and therefore it's invalid. That court rule. That's why I'm going to file a class action actually on the court rule. And I'm going to get that court rule and get up out of there because it's not legit. Why it's not legit? Because as I cited in there, I'm pretty sure I cited in there. If I didn't, I have to check my paperwork. But I'm pretty sure I cited in there, or I was waiting to respond back if I didn't already. But I'm gonna say right now that it violates the court rule on, I mean the court, not the court rule, the Michigan Constitution part that says that people have the right to prosecute their own cases. In Article 1, I forget the exact section. But I mentioned in my paper, in some future paperwork anyways, I know that if I didn't do it on this one, in the very first one, because I didn't know, what the hell subsection I was talking about. They didn't mention it, but I know I mentioned in some later ones sent to you guys. But anyway, so yeah. So it violates that right. And also the US Supreme Court case Murdoch versus Pennsylvania. And I got the volume number, page, and all that. I think I said to you guys before in the paperwork. It says that you cannot deny someone's constitutional rights by trying to make them pay money for something. A right's a right. Bringing something to the court's a right, be heard is a right. I don't have to pay money for that, criminal or civil case. Okay, so it violates due process. So all that's legitimate. They're illegitimate, that is, their arguments are using for that. Supposed to be acted on regardless of a prosecutor's approval or not. Okay, anyways, now as to her asking who's Mike, he's the manager at Area Towing. But we should have read it. It was in the document to explain that. So, okay. Anyways, as to the Penhollow, what she said about the quote about the Penhollow case. Okay. Now, first, I want to say, regardless of the Penhollow case, what she said, the Declaration of Independence of 1776 makes it clear the government has no power over the people. They derive their power from the consent of the governed, anyways. That's something that's clear right in there. Okay. the consent of the governed. I never consented and never will. So, number two, now her saying about the quote, I was just recently going to the law library. I'm going to need more time to respond to that. But I didn't have enough time to go over the Penhollow case, but if I remember it, I was just in the law school law library recently trying to verify that quote, because a lot of these quotes that I got, that I'm citing in the court, some of them I have read and some of them I haven't. This Penhollow case, I'm not sure on that. I admit that. I have to double check myself because a lot of these I get online, YouTube, and a lot of them have been shown up to be legit because I go to law library and I double check on them, the quotes. In the Penhollow case, if I vaguely remember, I think I did have a problem myself finding that quote, saying that exactly like that, but that's not saying it doesn't stand for that proposition. I'm sure it still does. I just got to go back to the law library and read it again. If I did read it, I kind of don't remember because I got a lot of stuff I'm doing. But yeah. So bottom line, I gotta check up on that case. So it'd be premature to rule on it yet, as to whether that Penhollow case is illegitimate to stand for that proposition. But I know U.S. Supreme Court cases still say it because it's all based off the Declaration of Independence. So there should be no doubt on that. And U.S. Supreme Court cases exist that say that Declaration of Independence is part of federal law, United States Supreme Court law, and it's the basis of the Constitution, so it's legit. That, as to the proposition that governments have no power over a human without our consent. All right, now, as to the summary judgment that she mentioned, Chapter 2 doesn't apply. That is not true, because since there's not a summary judgment in Chapter 6 of the criminal rules, then I forget exactly where it mentions that, but it's in the court rules or another law, but I remember reading it, it's been a while, that they make it clear that where there's not a relevant or similar proceeding in Chapter 6, then Chapter 2 is used for criminal cases. So that just totally it's not true. So the summary judgment, it does apply in criminal cases because there's nothing in Chapter 6. And regardless of that, in regards to the court rules, you got to remember, court rules follow the Constitution is the top dog anyway. That's the top law anyways. And due process right to have some considered and ruled on and denied in my case. I mean, the case dismissed because based on my constitutional rights. That's just something I have a right to anyways under the Constitution, regardless of court rules. Because the court rules come after the Constitution anyways, and they don't always follow the Constitution.
All right, 5 minutes are up.
All right. Well, I got more to say, but so I'm gonna move for an extension of time on that, based on my First Amendment right. I got some more to say.
I'm sorry, Mr. You wanted to move for an extension, so I just want to be. Are we selecting a jury next week or no? It sounds like he wants to talk more.
He does want to talk more, but I'm not adjourning it for that purpose. I am done with these motions. The motion in this particular case to return the motorcycle has already been addressed through the court regarding the fact that the court doesn't do that. He also filed lawsuits against individuals. Those were also rejected by this court as improper. And there's nothing to really address about that. It's already been decided. His motion to dismiss is denied. Despite his understanding of the law, and I'm not certain which law school he went to, summary disposition does not apply to criminal cases and is denied. And same is true for default in criminal cases. That is also denied. Jurisdiction is with this court, as I've ruled before.
As the hearing moves forward, the court begins to clearly outline the next steps. By this point, the key issues have already been addressed, and the focus shifts toward how the case will proceed. The earlier arguments no longer influence the direction, and the process continues under the court's structure.
Will not be addressing this issue again. The motion to dismiss is denied. There was one point that he did make with respect to due process that is going to compel where we go with this. He does not get to question officers except for in a trial. However, he is entitled to discovery in this case. And he mentioned that he did not receive a copy of the video, if there is a video, or if there's body cam, he's making a demand for that. And he is entitled to have a copy of any body cam that exists in this case and a copy of any police reports that exist in this case. So those items need to be turned over to the defendant so that he can properly prepare for any trial. And trial right now is scheduled for 1 week, so I don't think it would give him a proper opportunity to prepare. I will remove this from the trial docket for this upcoming week to and there is one place in which criminal cases does have a demand, and that is a demand for discovery. So I think he is making that demand for discovery, and I am going to require that the prosecutor provide him with that.
Absolutely, Your Honor. I think the issue was the standby counsel and him rejecting representation. So normally this is brought to the PD's office, but since I think it's been reaffirmed today that I'll figure it out. We'll get it done somehow.
What do you have an email, or are you just gonna, Mr. Martin, are you requesting to have the documentation sent to you via mail or email? How do you plan to receive it, sir?
First of all, to refer to me as Mr. I understand that's another one of the term Mr. is another one of the what's the words I'm looking for? I forget what it's called here.
All right, you can you would like to figure it out to get him that documentation, and I'm going to give you a new date.
Legalese term, that's the word I look for. The Mr. is a legalese term that's fraudulently assuming I'm a defendant and all that. But anyway, so
Your Honor, while you look for that date, I will just state on the record, if Mr. Martin, Eric Martin, living man, the individual sitting here before me today speaking, if you would like discovery, I would highly suggest that you give the court an email address or some method by which we can deliver that discovery to you, because I'm not trying to keep it from you, but if you don't help me to help you, I can't get it to you either.
I'm gonna give them my address, and I'd rather do it through my physical address here at the home. I just wanted to object to the term first, that's all, before I forgot, or you guys keep going on, don't let me do it. But same address I've been sending my demands to and all that, my paperwork. Taylor City, Michigan.
Whoa. I'm talking over because this is live. You don't want everybody in the world to know your address, sir.
I'm not worried about it, but okay. I mean,
okay.
Your Honor, we have the information. We can send it over to Ms. McDuffie if Mr. Martin would so allow.